Hello, everyone. This is Sean Tassi from Husch Blackwell's Higher Education Group. Today we are presenting on the European Union's new General Data Protection Regulation that takes effect in May 2018. We are very excited that today's topic will be presented by colleagues from the Pinsent Masons firm. Pinsent Masons is an international law firm with a significant presence throughout the EU. For those that don't already know, Husch Blackwell and Pinsent Masons have a cross-referral relationship that dates back many, many years. Our firms commonly collaborate on legal issues with international implications, such as the GDPR, and we're very happy to have them here today. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I would like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your questions via the question box. We truly appreciate audience participation and encourage you to submit questions, but because the presenters are located in multiple locations today, we may not be able to answer as many questions during the webinar as we typically do. We will do our best. If you have any technical difficulty, please click on the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is available in the resource list icon that looks like a folder at the bottom of your screen. This program has been approved for Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. To report your hours in Illinois, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. A recording of this webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. Joining us today from the Pinsent Masons office in London is Curious Wynn Davies and Nikki Piera. Curious is a partner at the Pinsent Masons firm and specializes in information law. She has extensive experience advising major universities and government bodies on data security and privacy matters, including GDPR compliance. Nikki is also an attorney at Pinsent and advises clients on a variety of data protection compliance issues, including GDPR. With that, Curious and Nikki, I'll turn it over to you.
Thank you very much. So this is Curious and Nikki's with me. We're going to be sharing the content between us, but we won't announce the changes. We're going to start just by looking at the agenda so everybody knows what you've got ahead of you. We're going to start off by talking about what GDPR is, particularly then focusing on why it's relevant to US universities and other higher education institutions. We're then going to move into, I guess, the key issue, which is what are the key concepts of GDPR, so why is it important? And that will start to give the indications of what you need to be thinking about from your own institution's perspective. We're going to finish off with bringing it all together and talking about what we're experiencing in the UK and Europe in terms of what universities are doing now. So that's bringing really all of those issues into a practical focus. If we get short of time, we've ordered the issues really in terms of the order of priority. So when it comes to the end of the list, we'll make sure we get to that last issue, which is what universities are doing now, and we may move through some of the issues in between a bit faster. But just starting then with what is the GDPR. Well, you've heard Sean announcing it stands for the General Data Protection Regulation, but certainly in Europe, GDPR is a common phraseology. Perhaps we hear a bit too much about it. It is the biggest change in terms of data protection laws across Europe, so it really is having a big impact for everybody. The big difference about it compared with our current laws is that it is directly binding, so it will come into effect across Europe immediately on the 25th of May. We don't have to have national legislation in order to do that. However, one aspect of it means that we will have to have supplemental laws to deal with areas that are not included within that legislation. And I've mentioned the 25th of May. That's certainly a date that across Europe everybody's working towards. So that is the date that we will have the GDPR in its full effect, despite the fact everybody's working towards that at the moment to try and achieve that compliance position. I guess it wouldn't be complete without mentioning Brexit, because I think people will be wondering what effect that will have in the UK. Well, first off, it will come into force in the UK in any event before Brexit, but the impact of these changes in law are such that we will actually be adopting all of GDPR in the UK in any event. That will be the minimum standard that we have to adopt. So there's no sort of wait and see what will happen. We know that that's the course that we need to take. So moving on then to just give an overview before we delve a bit deeper into the subject. What are the key changes that have arisen as a result of GDPR? I think it's fair to say that we're not wiping away the current laws in any way, but we're codifying a lot of the best practice that has built on the existing laws, with also a focus on accountability, greater accountability for those processing personal data, and also how data controllers ensure compliance as well. So those are key themes. But the big areas of change are higher fines, and we'll come to that in a moment, but that certainly is a very big factor in ensuring accountability amongst organisations processing data. Privacy notices as well, the notices that you give to those people whose personal data you're going to be processing. Again, that is becoming far more onerous in terms of the information that's required. Particularly then around consent, they're much more stringent requirements. And then data subjects have additional rights in terms of what they can demand of the data controllers. We're seeing big changes on the contractual front, particularly where you're contracting with other entities with whom you're sharing data in some way, and we'll talk more about that shortly. On breach notification, again, there's a much higher standard. So the need to notify any breaches that occur is much greater, and the speed with which you need to do it has become much shorter as well. Accountability I've already mentioned but there's a lot about keeping records of everything that you're doing so that is available if the question is raised. The other area is appointing data protection officers in order to help you to ensure compliance. And we now go to a poll question.
So this brings us to our first poll question. I obviously have the easy job here. Were you previously aware that the GDPR will take effect in May 2018? We'll give everybody a second to respond. So it looks about like 75% of the attendees knew that it took effect in May 2018, about 25% did not. So.
Okay, so now moving on to why the GDPR may be relevant to universities and organisations based in the US. So to kind of explain it to those who are wondering why they're actually listening to a talk about what is essentially an EU regulation. So the main reason is that the GDPR marks a significant expansion in the territorial scope of the EU data protection regime and brings a much larger number of overseas organisations within its reach. So when determining whether activities fall within its geographical reach, the GDPR considers not only the location of the business or the processing of the data, which is the position under the current law, but also the location of the individuals whose data is being processed. So on the slide there, we set out the position under the current law, which is that the data protection regime would apply where you're established in the UK. And by that, it doesn't necessarily have to be a legal organisation, but if there's any real and effective activity through some kind of stable arrangement under which you're established in the UK, then you would be subject to EU data protection laws. Or if you're established outside the EU, but we're using equipment in the UK or the EU for processing data. However, the test with regard to territorial scope has changed quite significantly under the GDPR. So as well as the position under the current law, there is now a new test which applies to organisations established outside the EU. So the GDPR applies to data controllers and processes which are not established in the EU, where either they offer goods or services to data subjects within the EU, or they monitor the behaviour of data subjects so far as that monitoring is taking place within the EU. So going a little bit further into what that new test could mean. So with regard to offering goods and services, this is likely to be very broadly defined. There's no restriction on the types of goods or services offered, and they can be offered at no charge, and goods include those offered in digital form. The key when considering whether you may fall within the new test is actually looking at the organisation's intention. So, for example, the availability of a website in the EU will not in itself fall under the test, as this isn't an offering of goods or services to a data subject within the EU necessarily. However, if there are clear indications that the data controller envisages that their activities are aimed at offering goods or services to data subjects in the EU, for example, if you're using a language which isn't common to the data controller's country but is common within the EU, or you're using an EU currency, then this will all be taken into account when looking at the intention of the data controller with regard to EU data subjects. The other factor to take into account is some processing of personal data must actually take place for you to fall within the scope of the regime. For example, a university website could offer the fact that it welcomes overseas students or offer distance learning courses to EU data subjects, but it's only once those data subjects actually provided their personal data to the university and you began processing it that you'd fall within this limb of the test. Although caveat that with the fact that with the amount of cookies and tracking that's sometimes used within websites, then arguably as soon as an EU data subject starts interacting with your website, depending on the nature of your monitoring activities, you could still be processing their personal data. The key is with regard to the location of the data subject themselves, so they must be within the EU. So it isn't relevant to their citizenship or nationality, it's actually their location at the time of processing. The second limb of the test is regarding to monitoring the behaviour of data subjects in the EU. So again, looking at that test in a slightly more detail, monitoring is not defined within the GDPR, but commentary suggests that the behaviour must be intentional, ongoing and directed. Therefore, the fact that an EU data subject merely visits a US university website would not in itself make the US university subject to the GDPR. However, if you are tracking individuals on the internet and using data processing techniques to profile an individual and then make decisions concerning them or analysing their preferences or behaviours, then this is likely to fall within the test. So the obvious example there is the use of cookies, and in this area, commentary suggests that persistent as opposed to session-only cookies, which are used to track a user's online activity across a number of websites, will most likely fall within the test, whereas the use of session cookies, which are only really used to regulate website functionality, are unlikely to fall within the test. So those are the different limbs under which you could find that even though you're operating in the US, you are actually subject to the GDPR. So there's a summary. As you can probably tell, this is a significant expansion in the territorial scope of the GDPR. And as we've discussed, the GDPR considers not only the location of the organisation or the processing, but the location of the individual whose data is being processed. And I guess in some ways this will create a level playing field for organisations established both inside and outside the EU. So looking more specifically about how this increased territorial scope could affect universities within the US, so we've just thought of some examples based on our experience with UK and European universities about how this may apply. So looking at how it could be directly applicable, obviously if you have any operations actually established in the EU, then you will already be subject to the current regime, and this will also apply under GDPR. But with regard to the new increased territorial scope, we thought situations, for example, where an applicant may be an EU data subject, and once they actually provide their personal data to the US, for the period of time in which they're still in the EU before they move across to America to join the university, then you would be processing their personal data while they're in the EU and would be subject to the GDPR. Equally, if US students, staff, or secondees moved from the US across to Europe during the time that they're within the European Union and you're processing their personal data, then you would be subject to the GDPR. And the final example we thought would be distance learning courses to overseas students in the EU. So once they sort of sign up to the course, or you're corresponding with them or processing payment, then you would be processing the personal data of an EU data subject while they're in the EU. The other way, which we think the US universities will be affected by the GDPR, is, as Karis touched upon, there are significant changes required with regard to contractual relationships between both controllers and controllers sharing personal data, and significantly between data controllers and processors. And for anyone not familiar with those terms, we'll move on to discuss that in more detail. But you'll find, and you may already have experienced this, that a lot of EU organisations are requiring their contracts to be amended as these new clauses have to be put in place in order to comply with the requirements of the GDPR. So we're now moving on to another poll question.
So our second poll question, were you previously aware that the GDPR could apply to U.S. institutions? I'll give you a few more seconds to answer. So again, about 75% answered yes, and about 25% answered no. So we'll turn it back over to Nikki and Kirius.
Okay, so now we're going to move on to look at some of the key elements of the GDPR. So having understood why it may be relevant, it's important to look at, well, what difference is it going to make to the current position? So the first thing we're going to look at, and perhaps this is the biggest stick that people are going to be beaten with, is the regulatory fine position. So under the UK law at the moment, the regulator can only fine up to a level of £500,000, whereas under the GDPR, there is the possibility of a maximum fine of 20 million or up to 4% of the total worldwide annual turnover of the business, which, as you can imagine, that is a very different figure. You'll see from the slide that there is a two-tier system of fines, so it depends on the severity of the breach, and the GDPR makes it clear which category each of them falls into. So it ranges from the 20 million to the 10 million, the 4% to the 2%. The other significant issue is that under the current law, if you're not a data controller and you're merely processing data on behalf of somebody else, you haven't been subject to any scrutiny or any fines from the regulator. That will all change, so whether you are a controller or a processor, you can be liable to fines from the regulator. There are certain factors that can be taken into account, and it's again important to put that ultimate potential fine into that context. So the regulators in each country, when looking at whether or not to fine, they have to make sure that it's effective, proportionate and dissuasive. And I think we're certainly seeing is that the level of the potential fines is meaning that people are taking compliance very seriously. The other factors that are taken into account will be the nature and gravity. So again, the type of personal data that is being processed will be highly significant, with the more sensitive, perhaps health data being of the highest significance. The number of data subjects affected as well is another important factor. And then in terms of mitigation, because again, people will never be able to be totally certain that they are totally compliant. So it's again making sure that you put yourself in the best possible position. And certainly one is cooperating with the supervisory authority, the regulator, being transparent with them. But another highly significant factor you'll see there is documented procedures. And this comes back to the real emphasis under the GDPR for having records in place and accountability and transparency. Again, making sure that you have the right security measures in place as well will be very significant. We thought it was worth touching upon enforcement outside the EEA because, again, you've heard about the extraterritorial scope, you've heard about the potential fines. So what will actually happen in terms of enforcement? Well, as well as the regulator enforcement, the first area to look at is the individuals themselves. So data subjects have a right to bring a claim in relation to any damage caused to them by any processing that is in breach of the regulation. Currently, it's unclear how the individuals would bring those claims, but it does appear that they will get the support of the local regulators in each country from their findings on the particular issues, and then be able to take those findings to the national courts, to the US courts, in order to persuade the courts there in order to commence the proceedings. In terms of the regulator enforcement, again, I think this is an area that will develop in terms of the ability for a regulator, for example, in the UK, to be able to enforce their fines against entities in the US. We're expecting to see regulators working together in order to achieve that. But throughout the process of looking at compliance, whether it's been under our existing legislation or GDPR, one of the clear factors is that the big risk to all sorts of organisations is not just the fines or the claims for damages, but the reputational damage that can occur if you don't demonstrate compliance with the regulation. One aspect to touch upon is that the GDPR also provides for requirements around having representatives within the EU, and the intention for this is in order to make it easier to bring claims against overseas bodies if they have a representative in the EU. But we won't go into detail around that now.
Okay, so looking at what is at the heart of the regulation is the concept, obviously, of personal data. So under the GDPR, the definition of personal data has been expanded to cover a broader category of information about individuals, including location data, online identifiers, genetic data, physiological data, economic data, and the cultural and social identity of that person. However, in many ways, the expanded definition is not anticipated to have too much further impact than the current legislation, because a lot of those identifiers were already generally considered to be personal data. So in many ways, this definition is actually just catching up with technological advances that have taken place since the previous legislation. However, for some organisations, the explicit inclusion of location data, online identifiers and genetic data may result in additional compliance obligations. And then the other concept is sensitive data. Under the GDPR, this is known as special category personal data. And again, all of the categories of personal data that were considered under the previous legislation are still considered as special categories of personal data, and then additional categories of genetic and biometric data have been added. The information regarding criminal convictions has been taken out of the definition of sensitive personal data, but is still subject to very tight restrictions, which essentially mean it's treated in a similar way.
Right, so now we'll go on to one of the fundamental principles of data protection legislation. Yet again, it's an area where we have got this fundamental principle already, but everything has tightened up to a higher standard. So the principle really that we have to adhere to is that all processing of personal data must be fair and lawful. And when we look at the lawful aspect, in order to be entitled to process personal data, you must have a legal basis for processing that is set out in the legislation. A number of bases for processing exist, but in practice there are a number that organisations will rely on. One of those is consent. Often people think that is the only basis for processing data, and it certainly isn't, and we'll talk about consent in more detail in a moment. Another basis for processing personal data is that you need to do it in order to to perform the contract that you have with that individual, or indeed to enter into that contract. And another concept is that it is in your legitimate interests to process that data, but that has to be balanced with the interests of the data subject and their rights of privacy. So what has changed? Well, the legal bases are essentially the same, but the very interesting thing, and the piece that is pushing organisations to think about this, is the fact that you have to determine the legal basis before the processing is carried out. And perhaps that sounds a bit obvious, but our experience has been that under current legislation, people will tend to think about what is my legal basis when a problem arises, and they have to work it out and justify it. The reason that you must do it beforehand is that when you come to providing privacy notices to data subjects, you actually have to spell out in that what the legal basis is that you are relying on. It also becomes important to determine which basis you're relying on, because your data subjects have stronger rights depending on which you actually use as your foundation. It leads neatly into consent. So as I said before, consent is one of the grounds, but it isn't the only one. And we have found that people have tended to rely on consent quite freely under existing legislation, because it wasn't terribly onerous to do so, provided you weren't processing sensitive personal data. And often that consent was implied by information provided. Under GDPR, that's no longer the case. And as I've said a number of times, we have a much higher standard. And well, why is that? It's because in the regulation, it says that not only does it have to be freely given, specific, informed, but it's also got to be an unambiguous indication of the individual's wishes. And that has to be provided either by a statement or another clear affirmative action. So they have to be signifying in some way their agreement to their personal data being processed. No longer can you use silence, so no longer can you just imply that the consent is there. You can't use a pre-ticked box, because that would be inactivity, whereas you need somebody to make this affirmative action. And it's also a burden on the controller to actually show that people have given consent. And again, going back to record keeping, you need to keep records of the consents that you've achieved. So you must be ready to keep systems that will actually demonstrate that consent has been provided. So looking at each of those elements and why they can be quite challenging, the first one is that it's got to be freely given. So it's got to be a genuine choice. So you can't bundle it up as a condition of providing a service unless it is central to that service itself. You can incentivize, but you can't penalize people who refuse consent. And you have to think about the relationship in question, because certainly from a UK regulator perspective, there is serious doubt as to whether employees can ever be in a situation when you're processing their data in connection with their employment of giving a genuine consent. Specific and informed means that actually when they're giving consent, it must be very clear to them what they're consenting to. So on the slide, there are a number of items that are listed that must be included before the consent would be valid. And notably, they can withdraw consent at any time. So consent provides quite an uncertain basis for processing personal data, because of the fact that the individual can at any time come forward and say, I now withdraw my consent. The requests for consent themselves, again, they must be unbundled and easy to understand. So what does that mean? Again, what you will expect to see is that whereas under existing laws, you might get one consent box in relation to a number of activities, whereas now it must be very clear each element that the individual is consenting to. It mustn't be vague, it must be clear. In terms of that affirmative action, as I say, the consent can no longer be a situation where you've pre-ticked the boxes for them. They've got to make this deliberate action in order to confirm their agreement. There will be certain circumstances where consent may be implied, but I think you should assume that most of the consents that you need to achieve will require some kind of indication, some kind of evidence that the individual has actually given that consent. So there's a need to keep reviewing the consent notices in order to check that they are valid. I've mentioned, I think, most of the issues are on the next slide in terms of the detail, and I would emphasise there the granular requirement to make sure that people are consenting to each element. If, in fact, all of the activities go together so that really they have to consent to each part of it, then a single consent may be appropriate. But there are certain aspects, for example, they're consenting to you as an organisation processing the data, but you also want them to agree that you can provide it to somebody else, then you would separate out those two elements so they are free to agree that you can process the data, but you cannot provide it to somebody else. So those are the sorts of ways in which you would break that down. Audit trails, again, you must make sure that you have a system such that in 12 months' time you could look back and say, yes, we have got consents from these individuals and we can demonstrate it. I said that the uncertainty with using this as your legal basis for processing, it means that you have to make it as easy for individuals to withdraw their consent as to give it. That needs to be simple and effective. You need to remind them that they have that right to do so. And as I mentioned, you need to be looking at this balance or imbalance in the relationship as to whether it's ever possible to have that consent. The key issue around consent, and I guess as well as the fact that it is a more onerous requirement, a much higher standard, with that goes the potential for a higher tier fine. So if you don't get the right consents in place, this is an area where you may be liable to that high level. The important thing here is that you'll have seen that it's a higher standard, there are risks around fines, but I've also said a number of times that it isn't the only basis for getting a legal basis for processing. So it is really important, and even more so than under the existing legislation, to determine whether this really is the best way for you to go forward, the most appropriate legal grounds to rely on. In terms of existing consents, this is again a bit of an issue in terms of, do we just start the clock running from the 25th of May? The answer is that you do need to make sure that all of your existing consents are GDPR compliant. And certainly if those have relied on pre-ticked boxes or you've relied on implied consent, then that won't be sufficient. And it does mean that you need to go back and get fresh consents again, or, as I mentioned, getting a different lawful basis for your processing. Looking at the whole question of other bases, the other factor that the regulator emphasises is that you mustn't give people an expectation that they are consenting and therefore also having the ability to withdraw their consent if in fact you're relying on another legal basis. So again, when you're writing your privacy notices, you should avoid putting in consent if in fact you're going to rely on the fact you're performing a contract and therefore you can rely on that instead, because you would give the individual the expectation that they can withdraw that consent. So looking at when it's not appropriate, again, if you can rely on the lawful basis, on a different lawful basis, then it wouldn't be appropriate to include consent, but also where you use it as a precondition of accessing a service, that's unlikely to be the basis that you could rely on. Instead, for example, you would say, I'm going to provide you with this service and therefore processing your data is necessary in order to perform that contract. So I don't need to get an actual consent for that purpose. And as we've said, the relationship piece, if you actually ask yourself, can they refuse freely without there being any consequence by them refusing, then that could be the right basis. But often if you decide that really it's an unbalanced relationship, and as I mentioned, the employee relationship is a classic one, then you are better to be looking for another basis for processing. And increasingly, that's what we're seeing, is that our clients who in the past had put consent in because it was a relatively easy factor to work into their privacy notices, now they are challenging that and working out, is there really another basis that you can rely on? But just reminding you there that when you are processing sensitive or special category data, you most probably will need to get consent for processing that sort of data. So it's often not avoidable. Looking at then the other aspect of making sure that you're processing data properly and in accordance with that principle of fair and lawful, the other key aspect is being transparent, making sure that the individual is aware of what you're doing with their data. And it's often a good test to say, if this was my data, would I be aware of what's happening? It's not simply an obligation on the data controller, but it's actually a right of the data subject to have that information given to them. And as with consent, if you do not provide this transparent information, you don't inform data subjects, then you can be liable to a higher tier fine. And increasingly, we're seeing instances in the UK of the regulator looking at particular scenarios and saying, we really don't think that the data subjects would expect you to be doing what you're doing with that data. And that can, of course, be matters of degree, that they expect a certain level of processing, but there are other things that you're doing that they wouldn't expect. So you should always be asking yourself, from the information we've provided, will that individual know what we're going to be doing? A lot of information must be provided, and it's going to be slightly different in its content and timing depending on whether the data was obtained directly from the data subject and whether there's any further processing that is intended. The notices, as with the consents, they have to be very clear, but the challenge, of course, is that in order to be clear, you would expect to have perhaps less content in there, but we're being required to include more and more content. But it's trying to say, give as much information as you can, but make sure that it is very clear and as succinct as you can. So what do we actually need to include then? So why is this going to be more onerous than where we are at the moment? So the privacy notices that you will be used to seeing are pretty standard in terms of the information that's required, but it's around the identity of the data controller. So you need to understand who is the controller as compared with the processor, and it must be clear in the notice who the data is going to. If there is a nominated representative, you would put that in there as well. The purposes for which you're processing, that's another key aspect. It's not enough just to say to a data subject that who you are and the fact you've got their data and what who you're going to share it with. It must be linked to a particular purpose, and you can only process the data for that purpose. So classically, you see situations where the privacy notice spells out what the data is going to be used for, but then somebody wants to use it for an additional purpose. If that's the case, you do have to go back to the beginning and provide a fresh notice. So certainly within the universities sector, we are finding that we are making sure that the categories of purposes that are included should be sufficiently broad to cover all of the activities that, for example, you will be carrying out in relation to the students. And those can be very wide-ranging, from the application phase through to the phase when you're actually providing teaching to them, There might be elements around the dealing with student accommodation. So a whole host of areas where you'd interact with the individuals and their personal data. So you need to include that in the privacy statement. And then anything else which is necessary to enable the processing to be transparent. Under GDPR, we need to add on these further factors. So I mentioned earlier, you need to spell out the legal basis for the processing. So you need to have thought about that, identified it, and put it into the privacy statement from the outset. I believe that is the right thing because that will create less problems later on, but it is something you need to have established. If you're relying on legitimate interests, I mentioned that as being one of the grounds that is a legal ground for processing. It's not enough to just say you are relying on that ground. You do need to go on and actually spell out what your interests are in processing that data. And there is a greater ability for data subjects to challenge those legitimate interests because you have actually spelt it out to them. Another key aspect is telling people if their data is going to be transferred outside the EEA, which in your case that will be the case, so it needs to be absolutely clear, and the safeguards that are going to be put in place in order to ensure that they have the same level of protection as is available under the GDPR. I'll leave the additional requirements on the next slide, which set out some more detail, but I'll leave you to look at those yourself, and we'll move on to contractual relationships.
So this is an area which is currently keeping us very busy, and as we touched upon earlier, under the GDPR, there are increased requirements on the clauses that have to be included in any contracts between a data controller and a data processor. So just starting by looking at the different role of a data processor under the GDPR, this is actually one of the biggest changes that has been made as a result of the GDPR. Previously, only data controllers were directly liable for complying with the data protection legislation, and that was then flowed down to data processors through contractual relationships. However, now, for the first time in many European countries, processors will have direct statutory obligations to comply with the GDPR in certain areas. The other big change, as we've discussed, is the increase in mandatory contractual requirements, and there's very prescriptive clauses that have to be included in any contract between a controller and processor. And interestingly, because of the fact processors are directly liable, it's actually an obligation on both parties to ensure that those clauses are included. So in some ways, that may help with contractual negotiations in terms of getting those minimum clauses into the contract. However, the fact that processors are directly liable, and that means that they can be liable for fines, means that there's probably more negotiation required around the allocation of responsibilities between the parties and the liability in terms of fines or claims from data subjects. So on that side of things, I think contractual negotiations could become more contentious. So the impact of the new requirements on data processors can be seen in a number of ways. So the relationship with supervisory authorities, so as we've said, they can be fined directly, whereas previously this was not the case. And data subjects themselves could bring action against a data processor. Internally, they have to put mechanisms in place to ensure that they are complying with their direct obligations under the GDPR, rather than just with any contractual terms in place with controllers. And then obviously, finally, the relationship with the controllers themselves. And at the moment, a lot of our clients within the sector are going through contract remediation processes where they're actually having to change the clauses in place with processors. So we've already touched upon the fact that processors are now directly liable under the GDPR, so we won't spend too long looking at this slide, but it is just a flag that processors can be fined for the whole damage if they're involved in a data breach, and the onus would actually be on a data processor to disprove this. So as we've said, this will lead to further negotiations between controllers and processors with regard to the allocation of responsibilities within a contract, and the liability and indemnity clauses are becoming quite contentious. So now moving on to look at the actual contracts, as this is one area where we feel that US universities will be affected by GDPR, as if you're in contracts with EU data controllers or processors, then the contracts will need to be changed. So previously, the Holy Trinity for a controller-processor relationship started with pre-contract due diligence and vetting. There then was the written contract itself, which on the next slide will go through the actual terms that were required. And then throughout the contractual life, there was ongoing monitoring required. All of these are still required under the GDPR, but each of those has been enhanced. So looking at the contractual relationship itself, all of the requirements under the Data Protection Act are still required, and those are set out on the left-hand side. But in addition, there are a number of further clauses which must be included in any controller-to-processor contract. So as you can see, that's quite a large number of different things that need to be covered, and that's why we're seeing quite a lot of work in this area in terms of remediating contracts and also updating new contracts that parties are entering into. Another area which also is included often in contracts is any international transfers of personal data. In many ways, the position isn't really changing as a result of GDPR, but in light of the higher fines and the fact that now data protection is very much on people's radar, you may find that people are taking more notice of these provisions and that you're being requested to enter into model clauses where data is being transferred from the EU to a US university, or obviously there is the sort of moving feast that is the US Privacy Shield as well. So although the position isn't changing as a result of GDPR, we think there may be an increased focus on this area just in terms of compliance.
Then moving on to breach notification, and again I highlighted earlier that things are tightening up here. Currently, we don't have an obligation in the UK to notify data breaches. So this could be a situation where you're aware that there has been something that's been available online for a period of time. We've had that situation with a number of universities. There's been some hacking of their systems to a full-scale cybersecurity breach. All of those would amount to breaches. You don't have to show that any individual's data has actually been accessed. It's the fact that it could have been accessed is regarded as sufficient. Going forward from 25th of May, there is mandatory notification required to the regulator, unless you could say that really it isn't going to be much of a risk. So the test is it's unlikely to result in a high risk for the rights and freedoms of the individuals. And I guess the issue that is particularly stressing people in terms of their preparations is the fact that you have to notify without undue delay and within 72 hours. Our experience is that actually when there are these breaches, it actually takes probably a week or so to actually work out what has happened. So I think we're going to have to get used to a tiered approach whereby the breach gets notified and more information is provided. The other key thing to notice in this area is that failing to notify could be one breach, and the breach by a leak of the data could be another. So you could end up with two fines layered on top of each other, relating effectively to two breaches. And we now have another poll question.
So this leads us to the final poll question, which is, were you previously aware that the GDPR contained breach notification requirements? The results are streaming in. We'll give it a few more seconds. Wow, 3 for 3. So this is right at 75%, 25%. Consistent throughout all three questions. So with that, we'll turn it back over to Curious and Nikki.
Okay, so moving on to look at the rights of data subjects under the GDPR. So normally if we were giving this presentation in the UK, we'd be looking at the differences between the current regime with regard to subject access rights and the regime under the GDPR. However, I think in the context of US law, although I'm would never claim to be an expert in data protection law within the US, my understanding is there isn't currently a general right for data subjects to access their personal data from data controllers, albeit there are some state-specific rights regarding certain information that data subjects can request. Well, under the existing EU law and under the GDPR, data subjects actually have a right to contact a data controller and request details of their personal data that's being processed and actually request a copy of that personal data. This is subject to certain exemptions, but as you can imagine, it is an extremely time-consuming and onerous task for data controllers to comply with this right. In terms of the GDPR, there have been some minor changes to this right, including the timescale in which a response must be provided. It was previously 40 days and is now 1 month, and the way in which the data is disclosed. The grounds under which a request can be refused or limited have also changed slightly. But I think from the US perspective, the sort of headline is the fact that this right exists, and to the extent the wider territorial scope of the GDPR applies, which we've talked about earlier, this means that you need to be aware of the fact that EU data subjects could exercise this right, and given the short timescale in which a response must be made, we would recommend that your organisation has a mechanism in place for dealing with such requests. And we hate to be the bearers of bad news, but in our experience, students commonly are aware of their data subject rights and are actually one of the people that we come across most often who actually exercise these rights. We also deal with quite a few disgruntled former employees and academics in this area, and some particularly colourful characters, including an ex-law lecturer, so you can imagine what that's been like. But it's just something to be aware of, again, given the wider territorial scope, and just have a mechanism in place, because once the request has been made, the clock starts ticking in terms of your response time. So the next slide just sets out in a bit more detail what you'd actually need to provide if a data subject request was made. And then the following slide sets out the exemption. So we won't go into the detail of that today, but it's more just to make you aware that this right exists. And then alongside the right of subject access, there are also other data subject rights. And on that slide, we've flagged those which were existing under the current regime and those which have actually been added as a result of the GDPR.
Conscious of time, and we don't want to miss out on the final section in terms of what we're doing for universities at the moment. So I was just going to mention a few headline points in the following slides. It's very much emphasised under the GDPR that you have to embed data protection into your systems, described as by design and by default. And that's what we're having to emphasise to all organisations, is that when any new facility is being developed, whether it's a new HR database or anything of that kind, you need to be thinking about data protection right in the centre and build it into the security systems from the outset. A number of people talk to us and say, well, they didn't think about that when they were building it, and it now becomes very difficult to put the necessary measures in place to ensure compliance. So it's very much talking about that from the beginning. The other key aspect of that is data protection impact assessments. And essentially these are tools to make sure not only that you are making the right assessment from the outset in terms of the processing that you're carrying out, perhaps the measures of security that you're putting in place, and the expectations of privacy of the individuals, but you're also keeping a record of doing that. So it achieves the two purposes, one of making sure you make the right decisions, but if you are challenged, it also gives you the ability to evidence the fact you've done this in the right way. Some details again in the slides of what you're required to do as part of those impact assessments, and we'll let you have a look at those yourselves. Just then, the following slides are about recording all of this good stuff that you're doing, and I think that again is a message certainly to take away, that you need to keep records. When clients are calling us to ask about how they should approach a particular issue, having talked it through with them, we are always saying, make sure that you keep a record of this, so that you have that to show to a regulator or an individual data subject should they ask you about that. We'll leave you to have a look at those slides. So I think if we come to the final couple of slides, which are around what the UK universities are doing now, and if we can mention a number of those. So we've been talking to Husch Blackwell about a particular project that we've been doing in the UK. So back in the autumn, we were approached by a consortium of 48 UK universities, and they talked to us about the particular documents and pieces of advice that we could provide to them at this stage to put them in the best place to achieve compliance. Following on from that, we had a workshop with them to make sure that everybody's needs were taken into account, and we prepared a template set of documents, which I'll come to explain in a moment. But leading on from that, there were many universities who didn't manage to get into the consortium in time, and that's something now we're talking to those further universities to make sure that they have the same facilities available. Obviously, one of the key aspects of that was making it cost effective for those universities, but the other aspect, it's a sector where it is felt that actually having a common approach to these issues can be very helpful indeed. So I was speaking to a university yesterday, and they were pleased to hear that there would be the same approach. So when they're dealing with agents in different countries who are responsible for recruiting students, at least everybody will be taking that common approach with them. So there will be a standard that develops. So just looking in a bit more detail as to what we have produced. So Nikki has explained the differences between controllers and processors, but you also have situations where two bodies may be actually sharing data, but you're going to be using them for your own independent purposes. There may be some overlapping purposes, but there are also independent situations. So an academic collaboration between two higher education institutions, there could be knowledge transfer, other sorts of research that is done in collaboration between two entities, and we've listed some more in the slide, but you can see there would be a need to share data, and it's very important that gets regulated by a contract covering the right provisions. So we put in place a template set of clauses to deal with that. Likewise then, the key area of processor relationships, this is an area that is highly specified by the GDPR, as Nikki mentioned. So we put in place template clauses, which unfortunately are quite lengthy due to the GDPR requirements, but they have a standard template that they can use for that. And then we worked on various variations around it to make sure that they could cover any transfers of data outside the EEA, whether it's to the US under Privacy Shield, or whether it's to other countries under the model clauses, or else on the basis of individual consents. We also dealt with a number of student contracts, employee contracts, volunteer contracts. So again, they have the right provisions to use in those circumstances. In addition to that, it became clear when we were providing the advice that a number of advice notes were required. So again, we provided those guidance notes so that it was easy to use the templates, and also when we went into areas outside of that, such as the data subject rights, we provided that additional help to them. Outside of the consortium work, we've also been helping draft the privacy statements that I mentioned earlier to cover all of the GDPR requirements, for example, for students, but also those required for employees and employee contracts, dealing with student accommodation agreements, also the privacy impact assessment templates to make it easy for each organisation to run that privacy impact assessment by having the guidance and templates that they need to complete. And then finally, another quite key area is making sure that the data protection policies that each organisation has in place are brought up to the GDPR standards, and any other related policies such as document retention, IT policies, etc. So I think we're just on time here, and we've come to the end of what we wanted to say. So I'll hand back to Sean in terms of bringing proceedings to a close or answering any questions. We're in your hands now.
Well, thank you very much, Curious and Nikki, and we want to thank everyone for joining us. I know that a few questions streamed in during the webcast, and we will do our best to respond to those individually since we're out of time. But again, special thanks to Curious and Nikki for really a fantastic presentation. If you haven't already done so, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback really assists in providing quality future programs. As a reminder, this program has been approved for Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin CLE credit. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. The recording will be available for about 2 weeks. This concludes our webinar, and thank everyone very much.